Welcome to Folsom Prison Blues, where we talk about criminal justice, incarceration, substance use, and other related topics. Today we're kind of doing a criminal justice theme. I'm going to talk about the legal system for criminal defendants, like what the process is if you are arrested and charged with a crime. So under your Bill of Rights, the first 10 amendments to the U.S. Constitution, you, as an American citizen, enjoy certain rights and what is the word? Protections, okay, under the law. So in other words, when you get arrested, when your liberty is taken, they can't just do whatever they want with you. They have to follow due process. And due process says that you have to be arraigned within 72 hours of arrest. If you do not get arraigned within 72 hours of arrest, they have to release you. And if they don't, then you'll get into the realm of habeas corpus, and that's another video for another time. So your arraignment is your first court date, and all that is, it's no more or no less anything other than these are the charges against you. Do you understand? And do you have a lawyer, or do you want us to appoint one for you? So you'll go into your arraignment, and you're going to see the judge, and he's going to call your case, and he's going to say, Mr. So-and-so, you're being charged with 2 felony counts of being way too handsome in public, and a misdemeanor for, causing a public disturbance for your transcendent handsomeness. Do you understand that? And it's just yes or no. This isn't a time for you to start asking questions or tell your side of the story or say whether or not you're guilty. Don't do none of that. They won't let you if you try. It's just, these are the charges. Do you understand that? They'll also ask you, do you have the funds to hire your own attorney, or do you need one appointed for you? Most people get one appointed for them because lawyers are very, very expensive. I mean, you're looking at least $5,000 just to retain an attorney. Let alone go to trial. Usually that retainer will get you up to prelim, and then from there it's even more money. It's very, very expensive. But so I'll choose the public defender, or I'll hire an attorney, and then they'll say, okay, if you're going to hire an attorney, we'll give you 2 weeks to do that, and we'll come back and reconvene. At that point, you have to waive time. And really at this point anyway, you're going to be asked to waive time no matter what, because under the 6th Amendment is your right to a speedy trial. You have the right to have your case brought to trial within 60 days of arrest. You have the right to that speedy trial, okay? But there's ways to lengthen that, right? And that's called waiving time. And they're going to ask you, do you want to waive time? Yes or no. If you're confused about what that means, you'll ask an attorney. There's going to be a representative of the public defender there, kind of like quasi representing you, while at your arraignment, and you can ask them if you're confused. But at this point, most people will waive time, even if it's just 10 days or a week until the next, little court date, which will usually just be like a continuance or something. But yeah, so a quick word on public defenders and attorneys. Public defenders get a bad rap because, you didn't hire them and pay them these big fees that criminal defense lawyers charge. They work for the county. They have a set salary no matter how many cases they win or lose. So it'd be logical to say that, their heart might not be into your case, because whether or not you get fucking screwed or not, they still get their paycheck. Now, there are public defenders who go to work there on purpose because they believe in helping criminal defendants who can't afford their own attorney. They believe in helping, the little guy. But not all of them. A lot of them are just getting a fresh start as an attorney, and they'll usually start there and then go on to get their own practice. But not all of them. So, it's hit or miss with that. But you might save yourself some money because, if they have just a real basic case against you and they kind of have solid evidence, there's not really a paid attorney isn't necessarily going to get you a better deal or a better outcome, right? So a lot of people also think, oh, if I get a paid attorney, I'm for sure going to get a lesser sentence or, let off the hook, or not necessarily. It all depends, okay? So that's your arraignment. So basically what will come next after your arraignment is what's called prelim. That's your preliminary hearing. Now, depending on how many times you waive time, the preliminary hearing has to come within a certain amount of days after your arraignment. But like I said, most people waive time because they need to gather evidence to build their case or look at the charges against them and work shit out. So most people waive time. Sometimes it's advantageous to not waive time and push for speedy trial, because that's going to force the DA to like fumble and hurry up and have like that amount of time to present his case, which he's not going to have at trial, right? But most cases don't go to trial. And if you ever think about going to trial, think about this. You're going to be judged by 12 strangers. Looking at the evidence against you, what are 12 strangers going to think? And that's basically what that is. I'll talk about that in the next video, because this is going to be a 2-part video. So what you're going to want to do at this point is before you go to your preliminary hearing. See, a preliminary hearing is it's like a mini trial, right? It's where the DA kind of presents his case to the judge, and then the judge is going to determine whether or not he feels that there is enough evidence to hold you for trial. So a lot of times a case might get dropped at prelim because the judge is going to hear what the DA has, his evidence, and the judge might say, you know what, I don't believe there's probable cause here, and then the case has to be dismissed. So that can happen too. So your preliminary hearing is basically where the judge decides whatever case the state has against you, is that enough to hold you over for trial? 9 times out of 10, it is. They'll bring in their witnesses and the officers that arrested you and all that, yada yada, and 9 times out of 10, they're going to find a probable cause to hold you over for trial. So that's what prelim is. So before you go to prelim, you because it's your right, and you should do this if for no other reason than that, you have the right to understand the charges against you. You have the right to know who your accusers are, and you have the right to know like what evidence they have against you. And that's going to come in the form of what's called a discovery. It's a legal term. Your discovery is going to be all the evidence they have against you, all the witnesses who are going to come potentially testify against you. It's basically the DA's case, and they have to show it to you. So get your discovery and go over it with your attorney. Now, a lot of times, when you're arrested and charged with a crime, the DA is going to have a pretty good case against you. Like I said, like if you go to prelim, most cases get held over for trial. Most judges find probable cause. It'd actually be rare for them to dismiss it at prelim, but it can happen. It just depends. But kind of in a nutshell, most cases don't go to trial. What will generally happen is you will plea out and settle the matter that way. So what a plea bargain or a plea agreement is when your attorney talks to the district attorney and work out a deal, right? The DA will say, okay, well, I've got this much evidence, but if he signs for 2 years, I'll agree to that. And then your lawyer will come tell you, hey, he'll offer 2 years. The offer is 2 years, and then you can determine whether or not you want to take that. Now in California, like all felony counts, charges, they come with a sentencing scale, like a low term, a mid term, and a high term. So you can only get so much time for your charges, right? So the name of the game for plea bargaining is you want to get the lowest, you want to get the low term, or even better, plead out to a lesser crime. And that's kind of what happens. Like when you get initially arrested and charged with crimes, they kind of, to use the term, throw shit at the wall and see what sticks. And then later on down the road, they'll reduce it to a different crime and have you plea out to something lesser. So if you got into a bar fight, let's say, and you initially get charged with, disturbing the peace, disorderly conduct, and assault and battery, right? By the time, you start talking to the DA or whatever, your lawyer talks to the DA probably, okay, you know what? I'll drop the assault and battery if he pleads to the disturbing the peace. So that's kind of how plea agreements work, and that's what a plea bargain is. So we're out of time. The next video I'm going to make right now is going to be on just more detail into that, I guess. And I'm also going to talk about like jury trial and more about your rights and how that works. So stay tuned. No, I'm not a lawyer. Always seek proper legal counsel if you are being charged with a crime. But I have so much fucking experience with this shit, I might as well be a lawyer.